My name is Ross Emmett, and I'm the director of the Center for the Study of Economic Liberty here at ASU, that is part of the School of Civic and Economic Thought and Leadership. Welcome to another lecture in the Center's series, Perspectives on Economic Liberty. The Perspectives lecture series emerges from its mission, which is to evaluate the contribution of economic liberty to human betterment. One of the ways we pursue that mission is to invite a variety of guests who will interrogate our center's topic, evaluating its role in human betterment for good or evil. So maybe I should say ill. That's what I actually had in my notes, not evil. The perpetual war between good and evil. There we go. We just got it right there. We also revisit the history of economic thought and the debates over economic liberty, and we consider the relationship of economic liberty to other values and freedoms that we possess. Our speaker today is Jonathan Adler, who's professor at Case Western Reserve University School of Law, the inaugural and current holder of the Johann Verhey Memorial Professorship, current director of the Coleman Burke Center for Environmental Regulation, and a widely respected conservative in the field of environmental law. I first met Jonathan when we both served as summer fellows at the Property and Environment Research Center in Bozeman, Montana. We've had a couple speakers from that center come in the last couple years to speak as well. And indeed, it was clear at the time when we were both there that his star was rising, and it has. Today, he's a leading scholar in environmental law as well as other fields of regulation. Hence, he was the first person I thought of when last June the Supreme Court overturned Chevron Deference in Loper Bright Enterprises versus Raimando. Let me welcome Jonathan to ASU and to Skettle, and Jonathan, take it away.
Great. Thank you. It's a pleasure to be here, and I always appreciate the opportunity to talk about administrative law, one of my favorite topics, and hopefully it's a favorite topic of a lot of yours. Since you're all here, I assume you all already knew, as Ross mentioned, that this past June, the Supreme Court, in a case called Loper Bright Enterprises versus Raimando, and a companion case called Relentless. I'm partial to that name, but that's not the official name of the case. It'd be nice to refer to it as the Relentless case. Overturned Chevron Deference, and this case is one of multiple cases over the last 4 or 5 years where the Supreme Court has restrained the power of federal administrative agencies. Administrative law is one of my favorite subjects. It's a course I often teach. I haven't taught it for a couple of years, and it's certainly interesting preparing to teach it this spring to see that as a result of this decision and other recent decisions that administrative law is not quite what it used to be. And what I want to do over the next 50 minutes or so is say a little bit about this opinion, why it matters, why a lot of its impact might be different than a lot of what people have said about it, both positive and negative. There are ways in which its impact will be perhaps greater than some people think, and other ways in which its impact is probably less than some people either hope or fear. But that we're certainly at a very pivotal time in the context of administrative law and in terms of what power federal agencies have, not just because of this decision, but because of a range of decisions. So just in terms of some background, it's worth noting that in addition to the Loper Bright decision, over the last 5 years, we've had decisions in which the Supreme Court has rejected the authority of agencies to address so-called major questions without clear legislative authorization, cases in which the court has made it easier for regulated parties to challenge the basis of regulations that they are subject to, as well as to challenge enforcement actions against them, and cases reaffirming that even in the context of regulatory enforcement, things like the Seventh Amendment's right to a jury trial aren't sacrificed, that those rights still must be preserved. The decision in Loper Bright, though, probably has gotten more attention than any of those other decisions, in part because it overturned a 40-year-old precedent, in part because in overturning Chevron Deference, many see the court as taking a more direct challenge to federal agencies, or posing a more direct challenge to federal agencies. So since I'm assuming the vast majority of you are not lawyers, out of curiosity, how many folks are lawyers? So a few. So I'm correct. Most of you are not lawyers. I want to spend a little bit of time kind of providing some legal context for this thing called Chevron Deference. Say what it is, because while you may have heard that Chevron Deference is gone, may not know a lot about what it actually meant in practice. What it is that led us to the point where the Supreme Court would overturn a 40-year-old precedent and reject a doctrine that had been, in many respects, the focal point of administrative law classes, administrative law study, why the court would decide to do that, and then say a little bit about what I think happens next, where I think we're going, what I think we should expect from future cases, and then certainly leave time for questions and comments insofar as we want to unpack some of these questions. So just as kind of initial matter, and I always, when we're talking about the nature of federal power, I always want to start with the Constitution. I am one of these folks that carries one in my pocket. My daughters make fun of me for that, but it's handy in class. It's not as handy at the dining room table, but it's worth, though, when we're talking about the power of federal agencies, it's worth just reminding ourselves of the constitutional context in which this arises. The Constitution sets forth our structure of government at the federal level. It creates the three branches of government that are responsible for the enactment, execution, and interpretation of federal law. It first creates a Congress, a legislative branch. If you actually look at the Constitution, the way it was originally written out in long form, it's very instructive to realize that it's in two columns written in that long script. That entire first column is Article 1. The first branch, the legislative branch, the source of lawmaking. It's not an accident that it's first. It's not an accident that it's the most detailed and the longest and most prescriptive. The other column is not only Article 2, which is the executive branch, Article 3, which is the judiciary, but also all the other aspects of the original 1787 Constitution. So the Constitution creates a legislature. It gives it the bulk of federal power, lists and enumerates powers in Article 1, Section 8, powers like to coin money, to establish uniform rules of bankruptcy, the one that gets the most action, the power to regulate commerce among the several states, and then creates an executive branch that, among other things, has the power and responsibility of faithfully executing the laws of the United States, carrying into execution those laws which Congress has enacted, and then a judiciary that, among other things, resolves disputes under those laws. Why do I go through this? Well, when we're talking about federal administrative agencies, right, you have Article 1 is the legislature, Article 2 is the executive, Article 3 is the judiciary. Article 4 is not administrative agencies. Article 4 is a grab bag of other stuff. Administrative agencies are not a separate part of the government. They are part of the executive branch. When administrative agencies are created, they're created because Congress has enacted legislation to create an agency, to give it power, to provide it funding, to give it responsibilities. And going back to the founding period, Congress has done that. Did that for perhaps different purposes, and certainly less often in the founding period than perhaps it did in the 20th century. But it's worth remembering that all administrative agencies are creatures of Congress in that they are the agents that are tasked with carrying into execution the responsibilities and the authority that Congress has given them. So in the early period, agencies did things like collect and administer tariffs or arrange for the construction of postal roads and things like that. Over time, we created agencies to recognize patents, to administer various regulations governing products sold in interstate commerce, labor conditions. These days, certainly things like environmental protection, approving drugs, and things like that. But whatever the reason the agency was created, whatever responsibilities it has, we always have to remember that in the background, and the Supreme Court has reaffirmed this time and again, they have no inherent power. The fact that there's an office with a nice logo and a fancy building in Washington, D.C., doesn't mean it has necessarily any inherent power to do anything. It has power because Congress enacted a statute and then entrusted the administration or implementation of that statute to a portion of the executive branch in an agency. And as I mentioned, the way Congress does this is by enacting statutes. And what arises in a lot of contexts is a question about, well, how do we interpret that statute? Maybe the statute was poorly drafted. Another course I teach is statutory interpretation, and we unfortunately spend a lot of time with a lot of statutes that are poorly drafted. Sometimes they're drafted well, but often not so much. Sometimes they address a subject matter that's complex. Sometimes the nature of the problem or the mischief that Congress thinks it's addressing is a little different than the way that problem evolves over time or the way it actually manifests itself in the real world. And sometimes they're just situations that weren't anticipated. And so we often have questions about what to do when a statute's unclear, and in particular, what to do when a statute's unclear and it's an agency that's trying to administer it. And we might think that that agency might have expertise in that subject area. We also might think that agency has a bit of self-interest. Maybe agencies want to aggrandize their own power. Maybe they have their own view about what mission is they want to pursue. Historically, courts recognize that agencies are usually created for a reason, or we certainly would hope so. And often that might entail some specialization or some expertise in a given area, and that therefore courts should at least pay some attention to what agencies have to say. So I teach this old case where, a labor case where when federal government first starts adopting rules governing things like overtime pay and the like. And there's a factory that hires or employs individuals for fire control, basically an in-house fire department. And some of the people, as part of that job, stay overnight. And there's a whole question, is that working time or not? And in that case, the court says, we care somewhat about what the agency has to say, because the agency knows more about the different ways in which employers and employees arrange these sorts of circumstances, the different conditions under which workers work, whether or not sleeping time is working time, or whether hanging out in the pool hall that's in the firehouse is working time, and so on. But it was generally understood that courts were still making the ultimate decision about what does the statute actually mean. We generally think that when part of deciding a legal case for a court is to look at the relevant legal authority and to resolve the question of what the law says. But it was, again, it was understood that judges are generalists, agencies may have specialization, and that courts couldn't ignore what agencies thought about the statutes they administer or the statutes they enforce. But the courts were not obligated to defer to them or to take the agency's word for it. Now that changes. And interestingly enough, that changes by accident. And kind of understanding why the Supreme Court would decide to revisit or be willing to revisit a precedent like Chevron versus NRDC, it's important to understand that this doctrine that we talk about really was accidental. It was not intended. In fact, no one even realized the doctrine had been created when it was created. So the context of Chevron versus Natural Resources Defense Council is the implementation of the Clean Air Act. The Clean Air Act is a long, very detailed, very complicated statute. It's actually one of the first environmental statutes I ever got to work with. In fact, I think my first time to Phoenix 32 years ago related to one of my first Clean Air Act projects dealing with Maricopa County's state implementation plan under the Clean Air Act. Well, as long as the Clean Air Act is, as complicated it is, as detailed as it is, there are still parts of the Clean Air Act that just aren't perfectly clear, parts that are ambiguous. One of the things the Clean Air Act requires is that facilities when they're going to make changes that could increase emissions, they have to install additional pollution control equipment as part of the condition of their permit. So the idea, if you're making a change that's going to increase emissions, you have to adopt additional pollution controls. But one question is, how do we determine what constitutes an increase in emissions? Because what the statute refers to is stationary source. So we know that's not a car, because those are mobile sources. We know it's, a refinery or a factory or a boiler or a cement kiln or what have you. But if we're talking about something like a refinery, and in this case, part of what was a concern was a refinery, are we talking about each smokestack? Each discrete point at which things might be emitted? Or are we talking about the refinery as a whole? Or perhaps something in the middle, like a building, like a particular installation. Well, in the case of a refinery, we're talking about a facility that spans acres, of which there are likely hundreds of discrete points at which different sorts of things might be emitted. Well, the Carter administration had been interpreting the law to say, no, source is each discrete point. So you do anything operationally at the refinery that increases the emissions at any one point, that's the trigger for installing additional pollution control equipment. The Reagan administration comes in and it says, that really constrains operational flexibility. And if within the refinery as a whole, they're making changes, so emissions go up a little bit here and they go down a little bit here, but the overall emissions of the refinery haven't changed, that shouldn't trigger that requirement. And that's going to increase the operational flexibility without resulting in increased pollution. So that's what the Reagan administration does. Basically what they said is, source to us is, Chevron's refinery in, Yorktown, Virginia or something. Whereas the Carter administration's position had been source is the particular smokestack. The statute says nothing to tell us which of these interpretations is the better interpretation. There's nothing in the text, there's nothing in the legislative history, there's nothing in anything that we would normally think about as how to resolve this dispute as a matter of what the statute means. There were policy reasons to choose one over the other. The Carter administration, most of the major environmental groups liked one interpretation. The Reagan administration, the regulated industry, liked the other interpretation. Well, the Reagan administration adopts a rule incorporating this new definition, and they get sued by some environmental groups. It goes to the U.S. Court of Appeals for the D.C. Circuit. Then Judge Ruth Bader Ginsburg writes an opinion, very extensive, going through all of the text, going through all of the legislative history, going through all the history of the implementation, and kind of says, nothing here is really determinative, but Clean Air Act's about cleaner air, so we're going to stick with the more protective, more restrictive definition. The Reagan administration and the regulated community appeal to the Supreme Court, goes up to the Supreme Court, and the Supreme Court, only 6 justices were able to participate in the case for a variety of reasons, looks at this, and they reverse. And they look at this question and they do the same thing. Justice Stevens writes this really long opinion, unanimous opinion, going through the text, going through all the history, whatever else, says, look, there's nothing here that would tell us with any certainty what Congress meant when it used the word source, as between smokestack, factory, refinery as a whole. But Justice Stevens says, given that this is a statute that the EPA is administering, given the EPA has given us a reason for why it wants to do it this way, we're going to assume that this is the sort of thing that Congress had left to the policy discretion of the agency. But the bulk of the opinion is kind of what we would have expected at the time, a very extensive, thorough consideration of all the things that would bear upon this question of what this one word means or this phrase means in the statute. And the court unanimously, kind of uncontroversially thought, well, in this context, since it's left open, we think it's a policy choice for the agency. Well, but in that opinion, there's this one paragraph. And it's one of those paragraphs when you teach courses in law school, students love, because it's very clear, it's very prescriptive, and it reads like a very simple test. And that paragraph says, well, when we're confronted with a question like this, a question of statutory interpretation, where an agency is implementing the statute, first, we look at the text of the statute, and if the statute is clear, well, then that's what the law means. But if the statute is unclear, if it is ambiguous, well, then we defer to the reasonable interpretation of the agency, and by that we mean an interpretation that is permissible given the language. One nice little neat paragraph, very definitive. No one on the court thinks that this paragraph is announcing a test. We've seen the papers of all the justices on the court at the time. It was just kind of a summation, in Stevens' view, of kind of what they were doing. So the court decides in favor of the Reagan administration, but attorneys in the Reagan administration and the subsequent Bush administration, they see this paragraph, and they're getting their regulations challenged in court all the time. And they're like, this is a paragraph that says, if the statute's unclear, we win. And so they start putting that in their briefs when they're challenged and sued in court. Some lower court judges start seeing this. And perhaps for lower court judges, this was a bit of a gift because it kind of makes things easier. Right? I think the Clean Air Act's a fun statute. Everyone in my family thinks I'm crazy. Most of my colleagues think I'm crazy. But the average person probably doesn't want to sit down in the evening and pore over the Clean Air Act and, kind of figure out what the various provisions mean and so on. And, to be fair, that might not be your average judge's idea of a great way to spend an afternoon either. And if there's this really complicated case and you're in some, in the interstices of the statute and it's this really kind of obscure question that you will never encounter again. And you have a doctrine that says, well, if it's clear, okay, follow it. But if it's not clear, go with the agency. Gives you an incentive to go with the agency. And sure enough, that's what begins to happen. And the Chevron doctrine is born. But it's not even recognized as a doctrine for years after the actual decision. And again, the Supreme Court itself doesn't cite it for many years after the decision. It really kind of bubbles up from lower courts that we're resolving it as a way of, of deciding complicated cases involving complicated regulatory statutes. One question that came up initially was, how should we think about why this should be the rule? There were some folks, Justice Scalia was a very early proponent and advocate and defender of Chevron deference. For him, it was, well, these questions often end up involving policy choices. And if the question is who gets to make the policy choice, the appointed administrator of an agency like the EPA or a life-tenured federal judge, let's go with the at least somewhat politically accountable head of an agency over the judge. And he made that view probably in part because in the 1970s in particular, there was a tendency of federal courts to adopt really broad, aggressive, purposivist interpretations of statutes to force agencies to perhaps do more than agencies wanted. And Justice Scalia certainly thought that was wrong. And so he argued that there was this practical reason and that there was perhaps even a constitutional basis for this, that it was kind of inappropriate to have a doctrine that would give this sort of authority to judges rather than to the executive branch. Over time, though, the court, and Justice Scalia was not always a fan of this, the court actually settled on a different rationale. And the rationale the court settled on for why Chevron, it thought for a period of time was a good doctrine, is that we can assume that Congress either wanted this or would have wanted this had it thought about it. Congress writes a really big, complicated statute like the Clean Air Act. Congress knows that it's not resolving every possible question that could arise under that statute. But in giving all of this authority to the EPA to implement that statute, that perhaps it is reasonable to presume that Congress intended that the EPA resolve those questions, that perhaps Congress implicitly delegated that authority to the EPA. Now, one of the things that's controversial about this characterization is sometimes, there are some statutes where that's very explicit. There are some statutes where Congress very clearly says, here's what we want to do, here are the ways to do it, agency, here are the things you're allowed to do to figure that out, and that includes answering certain sorts of questions. And I'm all in favor of Congress being very explicit when it wants to delegate authority. There are other statutes where it's a lot less clear. Right? Congress will give an agency a broad goal, it'll give it some tools, and doesn't fill in the rest. And Chevron certainly embraced the idea that this delegation could be implicit rather than explicit. And that's essentially what lower courts began to, that's how they understood it, and that's what Congress, or what the Supreme Court had delegated to them. But over time, this began to create some problems, and some problems that the Supreme Court in particular became concerned about. One was one that I already hinted at, which is the idea that judges would increasingly use this as a shortcut. The statute's complicated. It's hard. Figuring out how subpart B2.3 interacts with subpart C4. You got to sit there and you got to draw diagrams. I mean, some of these statutes are a mess. But a statute being hard to interpret or complicated or difficult doesn't mean it's unclear. It just means you got to do the work. But a lot of lower courts, and you can see this in opinions, kind of said, well, we're just going to assume that because it's complicated, that the agency must have a reasonable interpretation. Justice Kennedy, for example, Justice Anthony Kennedy, in one of his last opinions that he wrote on the Supreme Court, actually complained about what he saw as the increasing, quote, reflexive deference that courts were showing to agencies, especially when agencies were asserting power that they had never asserted before. When an agency came along and said, we think we have the power to do this too. Courts were not actually doing the hard work of first seeing if the statute answered a question before deferring. So that was one problem. The second problem is, and this was a problem that Justice Gorsuch, when he was a lower court, wrote a bunch about in immigration cases. Right? We often think that Chevron's about environmental regulations and so on. No, it's across the administrative state. And Justice Gorsuch, as a judge on the U.S. Court of Appeals for the 10th Circuit, was concerned that in immigration cases, what Chevron meant is since agencies get to resolve ambiguities and get to use policy justifications for that agencies would change their mind. And that made it very hard for those subject to agency decisions to understand what the rules were going to be that they had to comply with. And again, Justice Gorsuch saw this as a lower court judge, not in the context of some big oil company, but immigrants trying to understand what were the rules they had to comply with to be able to stay in the country and things like that. A third problem that began to emerge, and Justice Kagan actually wrote a very important law review article that kind of documented some of this trend, although she didn't see it as quite the same problem that some of her colleagues do, is that Congress started legislating less and less often. That didn't mean that problems went away, and it didn't mean the demand for agencies to do things went away. So what agencies started doing is trying to fill in the gap. So in some senses, the old way an agency would approach a statute is Congress enacts a statute. It either creates an agency or it gives power to an agency that's already been created to solve a particular problem. EPA, do something about drinking water. Here's the Safe Drinking Water Act. Here are the things you're supposed to do. So folks, the EPA should look at the statute, say, okay, what's the problem we're supposed to solve? What are the tools we've been given to solve that problem? What are the other guidelines we've been given to figure out how to solve this problem? Let's do that. Let's faithfully execute the instructions we've been given. What was increasingly happening is there'd be some new problem, maybe a problem Congress hadn't anticipated when it enacted that statute, because maybe that statute was enacted 10 years ago, 20 years ago, 30 years ago, 40 years ago. And the agency's kind of pouring new wine out of old bottles. And in fact, in recent administrations, and we've seen this in the last 3 administrations very explicitly, but we've also seen this in some of their predecessors, quite literally a president saying, this is a problem, now go figure out agencies how to solve that problem. Go figure out what power you were given before that can be retrofitted or readjusted or reoriented to this new problem. I mean, some prominent examples we saw of that were certainly in the context of COVID response, where the Biden administration, for example, wanted policies to increase vaccination rates. Well, there was no statute that was designed or intended or created to increase vaccination rates. There were statutes about other things, like occupational safety. And so the administration sought to kind of essentially retrofit or repurpose those statutes. We've seen the same thing in the context of climate change. Statutory provisions in the Clean Air Act, written in 1990, 34 years ago, to deal with things like ozone and nitrogen oxides and particulate matter and carbon monoxide, being repurposed to deal with carbon dioxide, which is a very different substance emitted in very different ways, in very different quantities, much more broadly, but essentially using this statute to address new problems. The way I kind of think about it is, my daughter lives in the very top floor of our house, and maybe she needs something needs to be fixed up in her room, and my toolbox is in the basement. And so maybe she'll ask for help with something, and I'll grab the tool that I think I need. I'll grab a wrench, and I'll get up there and I realize I need a hammer. I don't want to go all the way back down to the basement. So I kind of realized if you take that wrench and you kind of turn it sideways and you're not, the wood that you're, whatever it is you're driving that nail into isn't too hard, it might work. I mean, that I can repurpose that tool, right? But we all know that's not what a wrench is for. We all know there could be collateral consequences, right? I might be more likely to hit my thumb. And there was an increasing sense that that's the way agencies were approaching things. They weren't going back to Congress and saying, hey, there's a problem. We have the expertise, but we need the power. We need the tools. Give us the power to do this so we can go do it. They've instead saying, well, we've got a wrench. We really would like a hammer, but that's too much effort. Going back to Congress is too much effort. They might not give us the exact hammer we want, so we'll do this thing instead. And so, these concerns had been increasingly rising up, and certainly over the last decade, increasingly you could see these concerns being expressed in Supreme Court opinions. So enter Loper Bright Enterprises and Relentless. Loper Bright Enterprises and Relentless were both boat operators in the Atlantic herring fishery. And they are both subject to regulation under the Magnuson-Stevens Act, which is the primary federal statute that regulates and seeks to conserve fisheries. And among other things, it authorizes the National Marine Fisheries Service to adopt fishery management plans to help us figure out how many fish can be caught and under what conditions and things like that. Well, one way you help enforce those sorts of plans is you put an observer on the boat to actually see what the boat's doing and what they're catching, and are they catching the fish at the right size and the right time and the right type of fish and that kind of thing. In this particular case, the National Marine Fisheries Service wanted to use monitors more, but Congress had not appropriated it the money to do that. So the National Marine Fisheries Service said, well, we'll just require observers and we'll make the boats pay for it, since Congress didn't give us enough money. And literally they pretty much said, insofar as our money runs out, you've got to pay for it. Well, Loper Bright Enterprises and Relentless and some other boat owners said, well, you don't have the power to do this. The statute doesn't say you can do that. The statute says you can impose regulations on what we do, but you didn't say we have to now create a spot in our boat and pay the salary of this person that's going to be, this effectively government official. And so they sue. And two separate lower court opinions in two separate courts kind of illustrate some of the problems we were talking about, right? One court says, the statute says this. The other one says, well, we don't know if the statute's clear or not, but this agency wins under either step 1 or step 2 of Chevron. Doesn't matter which. The Supreme Court takes those cases, right? And it's really interesting that these are the cases the court takes, because this is not a case in which there's some question about an agency having really particular specific scientific expertise about the riskiness of some chemical, or what's the difference between one subspecies and another subspecies of squirrel or something, right? This is a very basic question of who or what sort of power does the agency have? Does an agency get to say, Congress didn't give us the budget we wanted, so we get to impose those costs on the regulated community, even though Congress never said we could? Indeed, in this statute, even though Congress, in other provisions of the statute, made reference to where that sort of authority might exist, but didn't with regard to what the agency wanted to do here. Right? This is a pure question of who gets to decide what the agency's power is. Well, that's the case that goes to the Supreme Court, and in a 6-3 opinion, as you all know, this past June, the Supreme Court held that the lower courts were wrong to defer to the agency on this question. Chief Justice Roberts, writing for the court, said that the text of the Administrative Procedure Act tells us that courts resolve all questions of law in cases challenging agency action. What the statute means is a question of law. Right? We're not talking about which fish you caught or how big it has to be or what's the fish's mating season or anything like that. It's just, what does the statute mean? And Chevron deference, insofar as it requires courts to give up their interpretive authority and defer to agencies, is inconsistent with what Congress had enacted in the Administrative Procedure Act. He explained that this meant that Chevron was overturned. And as Justice Gorsuch wrote in a separate opinion, Loper Bright places a tombstone on Chevron no one can miss. But let me unpack this a bit, because certainly the way this was received was, oh my gosh, Chevron Deference is gone. The administrative state is over. Agencies won't be able to regulate anymore. We're all going to die. We haven't died. We're here, and the administrative state is not over. And again, for some of you, that's a good thing. For some of you, it's a bad thing. Again, as a descriptive account, the administrative state is not here. What's really changed is who interprets that delegation of authority that Congress has to enact for an agency to have power. Is that being interpreted by the agency in a way that courts have to defer? Agencies that, again, that might have their own interests, whether it's their own aggrandizement, their own view of better policy, whatever else, or is that going to be interpreted by the same entities that we generally rely upon to interpret statutes? If I sue Professor Emmett and under some statute, and we disagree about what the statute means, we go to a court, the court's going to decide what the statute means. If suddenly an agency is involved, no reason why that fundamental dynamic, that the dispute is going to be resolved by the court interpreting the statute, should be any different. Congress hasn't done anything differently. The statute doesn't suddenly become more complicated or harder to interpret because an agency is involved. Indeed, in some contexts, we have statutes that are routinely interpreted by courts without agency involvement. And then those same statutes get interpreted, and suddenly if an agency is involved, the agency would want to come in and say, oh, but now you've got to defer to us. You've been interpreting the statute in case after case after case, but now that we're here, you have to defer to us and use a different rule of decision. The court said, no, that's not how we're going to do things anymore. But the court doesn't say that it means you ignore agencies. In most respects, it's basically returning us to what was the case prior to Chevron, and indeed what Justice Stevens thought he was doing in the Chevron opinion, which is recognizing that sometimes agencies might know more about this than you do. Maybe they have a lot of experience. Maybe there are terms of art used in the statute that have a particular meaning in a particular context. Maybe, and this is often the case, maybe the agency was actually involved in helping write the statute. Maybe the agency can explain why interpreting the statute a particular way for decades and decades actually makes sense and works out well, and courts should probably pay some attention to that. But what they're not required to do is defer. They're not required to give up their interpretive authority and accept an interpretation that the court thinks is unconvincing or not the best interpretation of the statute because an agency said so. And what the opinion kind of makes clear is that we're replacing deference with respect. Recognize that, like, if it's a question about drug formulation, right, there may be language in the Food, Drug, and Cosmetic Act that is specific, technical, that the FDA knows more about than the agency. The court should respect that. The court, in evaluating whether the agency's interpretation is persuasive, should recognize that expertise. But the FDA doesn't get to come in and say, we're the FDA, we win. We're the FDA, the words mean what we say they mean. So for example, the chief says, well, I guess, and I should say that the chief says that this is grounded in that underlying structure. So if you go back to Federalist 78, Alexander Hamilton talks about that the interpretation of the laws would be the proper and peculiar province of the courts. This is what courts have always done and been understood to do. But at the same time, and this is from Chief Justice Roberts' opinion, the court has recognized from the outset that exercising independent judgment often included according due respect to executive branch interpretations of federal statutes. Right? So exercising independent judgment, that's what we rely upon courts to do, giving due respect to those that may be able to offer a persuasive interpretation. Right? Respect the agency's knowledge, its experience, its expertise, so hear them out, but don't give them the ability to control the outcome. As he put it historically, respect was just that. The views of the executive branch could inform the judgment of the judiciary, but did not supersede it. Whatever respect an executive branch interpretation was due, a judge certainly would not be bound to adopt the construction given by the head of the department. Otherwise, judicial judgment would not be independent at all. As Justice Story put it, in cases where a court's own judgment differed from that of other high functionaries, the court was not at liberty to surrender or to waive it. And in effect, the court said we should do the thing that, again, we've been doing for a long time, but there is one important difference, one thing that's different today than the time Chevron was decided, which I think matters. And that is that the way courts interpret statutes is different today than it was at the time of Chevron. I've argued and would argue that that's a good thing. The courts have become more textualist, less inclined to embrace broad purposivist readings in statutes, less aspirational readings, more concerned on what language did Congress actually enact into law, what language actually went through bicameralism and presentment, what language was voted on by both houses of Congress and signed by the president, and a much greater focus on that. So that's certainly different than at the time Chevron was decided. But the idea that it's primarily the court's opinion to figure out what statute should mean is in many respects an older approach and a longstanding approach. And it's worth highlighting this, right? Especially given the way this opinion has often been characterized. It's not as if there was not federal regulation before 1984 when the Chevron doctrine was decided. It's not as if federal agencies did not wield extensive amounts of authority throughout the economy prior to being granted this type of deference. They just had to do more work, more of a job to demonstrate that their interpretation of a statute, the authority that they wanted to wield, was in fact what Congress had given to them. And that's what's been restored. And the fact that sometimes agencies deal with complicated subject matter doesn't really change that. Right? So again, from Chief Justice Roberts' opinion, delegating ultimate interpretive authority to agencies is simply not necessary to ensure that the resolution of statutory ambiguities is well informed by subject matter expertise. The better presumption is therefore that Congress expects courts to do their ordinary job of interpreting statutes with due respect for the views of the executive branch. And that phrase due respect appears again and again and again in his opinion. Right? Where Congress is, as we talked about in the beginning, is the source of that initial authority. Congress is the entity that enacts the statute. Providing due respect to the agencies is in effect respecting what Congress has enacted. But it doesn't involve abdication of that judicial responsibility to interpret the law and determine what a statute means. So what does this mean going forward? Well, it means a bunch of things that are I think are important. Right? One is agencies will be less inclined and less able to engage in this practice of rummaging around through old statutes, trying to find authority to do what they want to do rather than having to go to Congress. If we want something that looks like the Clean Power Plan, that's something Congress could likely enact. It's not something that can be derived from Section 111 of the Clean Air Act, which is something the Supreme Court had decided in a case called West Virginia versus EPA. That language, the language in Section 111 was never anticipated to allow for comprehensive regulation of the utility sector. People would have thought you were crazy if you had suggested that provision of the statute authorized that sort of power in 1990 when it was enacted. So one thing it certainly does is it suggests that Congress has to be more active, agencies have to be more willing to go back to Congress to ask for power that they want to authorize. I think in the courts, it indicates that the court is also increasingly concerned about what sort of power agencies do and do not have. In terms of agency expertise, agencies are still often have expertise in lots of things. And if Congress wants that expertise to control, Congress retains the authority to do that. There are some that we're hoping the court would not merely overturn Chevron, but issue some broad pronouncement limiting the ability of Congress to give power to agencies, perhaps under something like the non-delegation doctrine. Court didn't do that. Again, some people are happy it didn't do that. Some people are unhappy it didn't. The court said nothing about the outer limits of Congress's ability to give power to agencies. What it's more focused on is let's make sure that agencies are only exercising the power that Congress actually gave them. Right? Our elected representatives decide what power agencies have. Agencies don't get to decide for themselves. In some respects, the era of the phone and the pen, for those of you who remember that famous comment by President Obama, that is over. Right? The president doesn't have the ability to say, well, Congress hasn't acted, so I'm just going to tell my agencies to figure out how to do this thing that I really want to do. In terms of, so it will constrain the executive branch in the sense that its ability to act without Congress will be limited. It will require agencies to spend more time actually focusing on the instructions that they've been given by Congress in statutes. I think both of those are very positive development. I think another thing that it will do, and we will, I think, see some signs of this relatively quickly, is that it makes it harder for agencies to change their mind. One thing that was an increasing concern certainly to some justices, I already mentioned Justice Gorsuch, is that agencies, if they had the power to determine what a statute would mean if the statute was ambiguous, they could also change their mind. And we've seen many examples of that. A prominent example relates to what's often referred to as net neutrality under the Communications Act. The last three administrations have gone back and forth about whether or not certain provisions of the Telecommunications Act authorize that sort of regulation. The statute hasn't changed. The statute hasn't been revised since 1996. Right? Regulating the internet comprehensively on a public utility model is a pretty big deal. I think it's kind of silly, but some people think it's a very important thing to do. It's a big deal. You would think if the Federal Communications Commission in 15 years ago says we have the authority to do it, 12 years ago says we have the authority to do it, and 5 years ago says we don't have the authority to do it, and 3 years ago says, oh no, we have the authority to do it again, you might think Congress would have done something in that interim. But no, again, the Communications Act has not been revised since 1996. That sort of thing is going to be less likely, and we're on the verge of a new administration. We will see, I think, relatively quickly that in areas where the Trump administration wants to change policy from the Biden administration, it will be somewhat more constrained. It will, and in order to change policy, we'll generally have to say the problem with the prior administration is that they violated the statute, because the Trump EPA is not going to get the deference that the Biden EPA wasn't going to get. No one's going to get it. And the argument's going to have to be based on this is what the statute actually says. And in terms of political accountability, I think that's a good thing as well, and will hopefully create greater political accountability and greater incentives for Congress to actually think about the statutes that it has enacted and whether or not those statutes need to be revisited, revised, repealed, what have you. There are some questions that Loper Bright leaves us with. One is the fact that Chevron was one of the most cited cases of the Supreme Court, certainly of the last 40, 50 years. It has been relied upon in hundreds, if not thousands, of lower court decisions upholding agency actions. There's a very real question about what we do with all of those cases, especially the ones that never went to the Supreme Court. The decision says, we generally believe in statutory stare decisis. If a court has said a statute means X, we will assume that is still true. And so that generally means, I think, if an agency regulation was challenged and a court upheld it and relied upon Chevron, that agency regulation is still valid and is not vulnerable. The problem, though, is that there are cases where what the court actually said is the statute's ambiguous, we don't know, and does that mean just that one regulation is valid, or does that mean the statute's actually ambiguous and the agency can change its mind? Does that mean that we should assume Congress gave the agency the ability to exercise policy discretion like that? We don't know how the court's going to resolve those sorts of questions. I think we will get a case on something like that, possibly this spring, but most likely next year. There are some cases that will arise that relate to that. And I think that something else we're going to see from this as a result of this opinion and some of the other opinions that the court has issued in recent years is a lot more skepticism about agencies asserting authority that it's not clear that they have. And in some cases, that's authority that agencies have been recognized or have been exercising for decades. Take one example from last week. Last week, the U.S. Court of Appeals for the D.C. Circuit issued an opinion saying that the Council on Environmental Quality does not have the authority to issue binding regulations under the National Environmental Policy Act, does not have the authority to issue regulations that tell other federal agencies what they have to do in terms of issuing environmental impact statements. And those regulations were often the basis for people suing, challenging agency noncompliance with NEPA. DC Circuit says the National Environmental Policy Act doesn't say they have the authority to do this. Supreme Court has never said they have the authority to do it. They've been doing it. Lower courts have kind of said, oh, Chevron, yeah, it's unclear, go ahead and do it for a long, long time. I think we're going to see more decisions like that. One that we might see relatively soon relates to whether the Federal Trade Commission has rulemaking authority. So the Federal Trade Commission, since the 1970s, has asserted the broad authority to issue regulations about what is an unfair trade practice. The original case involved octane labels on gasoline at the pump. But currently, the FTC is using this authority to do things like prohibit non-compete agreements. And that's being litigated now. And it would not surprise me at all if, in a world without Chevron, the Federal Trade Commission's ability to claim it has the authority to issue these sorts of regulations is rejected and that it's returned to Congress. So I promise I leave time for questions. So, I mean, my bottom line is that this case, it's significant. It's certainly, as someone who teaches this stuff, it's a significant case, and I have to redo my syllabus. I have to, I have to dredge up some really old pre-Chevron cases to kind of show how we used to do this sort of thing when we didn't have Chevron to rely upon. It's certainly changing the practice of administrative law in terms of what lawyers do in agencies and challenging agencies. And I think it's also important in that it really changes the underlying dynamic that agencies operate in a way that reinforces political accountability. So it's not a decision, right, that's going to lead to agencies atrophying. It's not a decision that's going to lead to agencies not being able to do anything. But it is going to require agencies to do the work of showing they're actually exercising the power they want to exercise, that Congress actually allowed them to do what they want to do, and put them in a position where if they don't have the authority to do what they want to do, that they have to go back to Congress and ask for it, the way that agencies did for basically the first 200 years or 208 years of our nation's existence, or the first 197 years, I guess, of the Constitution, and not just assume that they can freelance and make up this authority on their own and that they'll get away with it in federal courts. And so that's not the revolution that I think a lot of people have characterized Loper Bright as being. I think just in terms of the fundamental operation of our political system, it's a very positive development because it reasserts and reinforces where ultimate authority to issue rules, to issue dictates that the rest of us must comply with comes from, which is not from some office building with a bunch of well-meaning experts in whatever particular subject matter it is, but in fact comes from the people that we actually elect to represent us in Congress and who actually write and pass the laws. And again, while that's not a revolution and will not lead to the decomposition of the administrative state, insofar as it is something that gives Congress greater incentive to actually do its job and restores political accountability, it's certainly something that I think is a positive step. So I will stop there. I think Ross is going to, if any folks have questions, but certainly thank you for your time and for coming out tonight. Okay. Sure.
Hi, everybody. I'm going to keep my question. You can hear me, right? I'm going to keep my question simple. Having listened, I pared down my question, so make it a little easier for you. But also, that also means I'm turning to you to ask him the really hard questions. I'm tossing him a softball. Maybe it won't be a softball. But question is, why should I, as someone who cares about economic liberty and my economic liberty, why should I care about Loper, the decision regarding Loper Bright? And I'll let you take it from there.
Yeah, I think the most important reason to care about it is the point I ended on, which is the one of political accountability. I mean, the Constitution gives Congress a fair amount of power to enact laws, and depending on interpretation, Congress has perhaps exercised even more authority than it was originally given. But certainly under current law, Congress has the authority to do those things. And when the federal government is going to make choices about what sorts of things we are allowed or not allowed to do, what sorts of things might put us at risk of losing liberty or property. My own view is a system that ensures that the people that are making those decisions can be held accountable politically is really important. And right? The Constitution is not as libertarian a document, perhaps, as I would want it to be. But I think it's important that when we authorize the government to do things to solve problems that at least a majority of us or large portions of people in society need to be addressed, we want to make sure that those lines of accountability are there. And the idea that folks in an agency can simply decide that something is a problem worth dealing with and not have to go before the voters and not have to explain themselves, and that that can be shielded from political accountability and effectively shielded from judicial review is something that I think should be troubling. And so in that respect, I think it's important that these decisions to restrict economic liberty are decisions that should be made in the open and through a politically accountable process, and not the sort of thing that we should just accept because somebody who claims to be an expert thinks it's better for us.
Yeah, there we go. Couple questions. I'll go through here, but she had her hand first.
Why did it take so long?
Yeah, part of it is that Chevron was decided at a time when the view of a lot of folks, especially on the Supreme Court, was that lower courts were kind of out of control and kind of forcing agencies to do all sorts of things that agencies maybe didn't want to do. And that Chevron's one of several decisions at that period of time that kind of said to the court, courts, put the brakes on this. Congress doesn't pursue purposes to the nth degree. Congress decides, if Congress enacts a law, to reduce air pollution, it's not saying zero. It's saying we want to reduce air pollution, and that there are questions of degree that ultimately are legislative judgments. And so the idea of restraining lower courts from perhaps inserting their own preferences into when they engage in statutory interpretation was a concern. I think, at the time, there were a lot of folks, I mentioned Justice Scalia, because the political valence of Chevron when it's first decided, it was seen as a conservative decision. It was seen as a decision that was going to allow the Reagan and Bush administrations to deregulate more by reinterpreting statutes or by saying these statutes don't require what people think they do. And that gave it some support, and I think there was more faith in the executive branch not exceeding this power. I think the other thing is that if you look at kind of when discontent about Chevron started to arise, it's at the same time that Congress really starts legislating less. So when I worked in Washington, D.C. in the 1990s, the regular practice in the environmental area was Congress would reauthorize the major environmental statutes every 6, 7, 8 years. So there was a regular process of Congress going back to the statute and saying, here's what works and here's what isn't, here's where we did too much, here's where we did too little, we're going to do this and we're going to get rid of this other thing. We may have liked or disliked what Congress did, but there was much more interplay between Congress and the agencies, and so the ability of the agencies to freelance and to aggrandize their own power was a lot less. There are actually some good examples from the 70s, 80s, and 90s of agencies taking ambiguous parts of statutes and really running with them, and Congress coming in and saying, no, stop. We did not give you that much power. And of the major environmental statutes, one involving pesticides has been reauthorized in the 21st century. So Congress isn't revising these statutes. The problems we face change. Some problems we've solved, some problems we realized weren't problems in the first place. New problems emerge. We understand the problems better, so we realize the tools we enacted 20 years ago really aren't the tools we should be using. And Congress isn't coming in and changing that. And so that, and the fact that over the last 30 years, there's been greater and more centralized control of the executive branch. So beginning really in the Clinton administration, arguably, there is increasing control of agencies through the White House. So they're more responsive to the president's policy preferences, combined with Congress acting less. So there was more kind of centralized White House. Okay, we want to fix this problem. Let's figure out which agency we can task to do that with. And increasingly too, well, since Congress isn't going to do it, we're just going to do it on our own. And I think as those things increased, this wasn't a partisan phenomenon, right? The phenomenon of centralizing power in the White House and saying if Congress isn't going to pass the legislation we want, we will do it on our own, is something both parties have done. I can give you examples from every administration, from the Clinton to the present. But it's become more prominent. It's become increasingly the thing you look to do first rather than last. And I think at a certain point, the court's like, that's not how our system's supposed to work. And what seemed like a reasonable heuristic for dealing with the fact that a lot of this stuff is really complicated and we're just generalist judges and we might not be the experts, really became an opportunity for agencies to aggrandize themselves and to subvert the process. So I think that's kind of, if you think about when Chevron was kind of first emerging as a doctrine to today, that's really the change. And I think if you look at cases over the last 5-6 years, there are a bunch of opinions from the court, a bunch of oral arguments where it's very clear this is what they're worried about. When did Congress say you could do this? Where did you think the authority for this was? Shouldn't Congress be authorizing that? And I think the justices became convinced that among the things contributing to that problem, that Chevron deference was doing that. Now, there are other things that contribute to that problem too. So this isn't, it's not a miracle fix that's going to suddenly make Congress be more involved again. But I think that's the dynamic, and I think some of the stuff during COVID, and I think some of the climate stuff and arguably some of the stuff the first Trump administration wanted to do with immigration as well, without congressional approval, were probably some of the breaking points, because these are like really big, consequential policy decisions that people really care about, and these are really things that Congress should be doing, right? The federal government, if the federal government wants some kind of vaccine mandate or vaccine incentive, they should go to Congress. If the federal government wants to impose an eviction moratorium under the guise of preventing the spread of disease, that's something Congress should do. And in fact, that's something Congress actually did temporarily. Congress chose, with the CDC eviction moratorium, Congress chose not to renew it. And the Biden administration did anyway. That was one of the first of these decisions where the court's just like, where do you think you can just do this? And I think those were kind of breaking points, because these were really big, consequential. These weren't little, regulatory issues that the industry cares about, or the people that really know about, but kind of escape broad attention. These were broader, more systemic sorts of actions that really highlighted that this was going on.
First of all, I want to thank you for, I thought you did a wonderful job explaining Chevron and what has happened since that time. But having litigated in federal courts for a number of years and being in front of federal judges, the change in Chevron that you're talking about is essentially putting in the hands of generalists who are not elected or serve for life, making decisions with regard to administrative agencies without as much deference, and on the theory that Congress will then, if they reject it, will do something about it. So that now, as you've just said, they are litigating less now. So how does this improve political accountability by putting it in the hands of judges who are generalists? In many of these instances, don't know what the heck is what really is going on. They have a difficulty, and from my experience, they're not going to do more work. When you're asking them to do more work, they're not going to do more work. And I think an assumption that they're going to do more work when you're talking about people who have life tenure is specious.
Well, I mean, that's certainly something we'll see, right? I mean, it is interesting. I think that and I mentioned this briefly, the way courts interpreted statutes was a lot more freewheeling in the late 20th century than it is now, right? Justice Elena Kagan famously made the comment that we're all textualists now. I mean, the extent to which the text and structure of the statute that's enacted controls the inquiry, I do think constrains judges more than what was done before. Is it a perfect constraint? Of course not. And judges are people too, and they have cognitive biases like the rest of us, and that's why we have 3 judge panels on appeals to help compensate for that and so on. So the claim is not what's the perfect approach. It's rather, Justice Scalia would in defending textualism, would, tell the joke of the two guys that are out camping and they come across the bear and the bear is angry and it's going to come at them. And the one guy stops to tie his shoes. And the other guy's like, well, why are you tying your shoes? That's not going to help you outrun the bear. He's like, I don't have to outrun the bear. I just have to outrun you. And the issue here is, right, not what's the perfect system, but what's better than the alternative. And if the choice is between judges having to do the work to figure out what statutes mean, giving due regard to what agencies tell them, or letting the agencies run the show, I think there's a very strong argument that the latter is proven to be very problematic and very corrosive of political accountability. And if Congress doesn't respond when we need new legislative changes, in some respects, that's our responsibility. And now, we shouldn't just say, well, because somebody's in an agency, they just get to solve it for us, and let's hope it was the right person with the right ideas, because that's not really how our system is supposed to work. But I do think courts are interpreting statutes generally better than they used to. Again, not uniform, not perfect, but I do think that has helped. I also think there are signs that when Congress has to legislate, it does. It just is very, what's the word I'm looking for? It's acculturated, that's not the right word, but it's to the idea that it can get away without legislating, and that the executive branch will fill the gap. And then depending on which party you're in, you either celebrate what the executive did or you complain about it. And if you're a state attorney general and it's the other party, you sue them. Right? I mean, that's clearly not the way it's supposed to work. But you look at things like the VA reforms that Congress enacted, but no one expected them to do. COVID legislation that was enacted. It's not as if Congress is incapable; it just prefers not to. If there are current problems which we need to address, then we should be putting pressure there. So my claim is not this is a perfect fix. My claim is that the problems that Chevron created and contributed to reached a point where they were greater than the sorts of difficulties Chevron was supposed to solve. And I clerked on the DC circuit where all we see is administrative law cases. And I can tell you, a situation in which, and I clerked for a fairly textualist judge, it was really complicated. And the agency gives you a really good explanation. And the well-paid attorneys for Chevron or whomever on the other side can't tell you why the agency's full of it or why they're ignoring something. It's not unreasonable for you to say we're persuaded by the agency. And that's perfectly consistent with what the court has done. But what it doesn't mean is that when we first time looking at Section 126 of the Clean Air Act in a case, and it's there's a real incentive there to just say, this is hard, I'm just going to give it to the agency. And that, we want to disconnect that, because sometimes things are complicated for a reason and you actually have to figure it out. And we want a system, I think, that encourages figuring out what the statute actually means. Just last point on that, I mentioned the case about the firefighters staying overnight. That case, that was more or less the facts in this case called Skidmore. Right? The resolution in the case of Skidmore is not ignore the agency, which is what the lower court had done, but actually listen to the agency and consider whether it's persuasive. And recognize that there are a whole bunch of things that may give an agency's interpretation more or less weight, like the degree technical expertise is required, the extent to which the agency's been consistent over a long period of time, the extent to which the agency offered its opinion when the statute was first enacted. But there are a whole bunch of things which we say make an agency's interpretation more persuasive. And that makes sense. And requiring the agency to point to those things, right? It's pretty good. When an agency like the EPA comes along and says, we've interpreted Section 111 of the Clean Air Act this way for the last 25 years, but now that we've decided climate change is a real problem and Congress isn't enacting something new, we're now going to decide that Section 111 of the Clean Air Act gives us the authority to completely remake the utility sector. We should scratch our heads and say, how is it that this provision in the statute gave you this awesome, amazing power that no one knew about until now? Right? And under Chevron, if a court thought it was at all ambiguous, they would have been required to accept the EPA's interpretation. And that's kind of weird, right? I mean, in the sense of normally we would say that's a pretty big leap. And so again, it's a question of who is outrunning the bear. I think this approach, or who outruns the other person, not outrunning the bear, right? Neither of these is perfect. All the branches of government still have a lot of things to do, but I think it's better than the alternative.
And we have time for a couple more questions if there's one in the back here.
No. Right. So there's a concern that sometimes what happens is that interest groups that want a particular outcome and want the agency to adopt a policy sue the agency and then maybe agree to a settlement that is something the agency couldn't have done on its own and get it blessed by the court as part of the settlement. And there's certainly examples where people think that has occurred. And we're certainly some examples where it looks like that's occurred, where the agencies have agreed to timelines or to implement certain things that it's not clear they had the statutory authority to do. I don't think it really gets to that. I mean, the real issue there is whether courts are going to examine consent decrees. And this is a broader question, or a broader problem, I would argue, in the judicial system generally. It occurs with class action settlements a lot too, right? So these settlements where big class action against the manufacturer of something, thousands of consumers, and the award is like every consumer gets a coupon for $50 off the new version of the thing they're complaining about. There are 1,000 people in the class times 50. Oh, so 50,000. But okay, to me, it's more than that. And the attorney's fees are based on the theoretical value of the settlement, not what consumers actually get. And there is, just like with sue and settle with agencies, a lot of courts are very quick to say, well, if both sides agree to it, who are we to interfere? So that's a different sort of problem, and I think that exists with class action litigation. I think it can exist in the context of litigation against federal agencies, but it's a different sort of problem and requires a different sort of fix.
And with the Trump's new nomination of the head of the government efficiency program, the Doge. Yes, and Elon Musk and what's his name, Ramaswamy. How do you think the agency is going to affect us? These nominations will affect the next couple 4 years.
So there's an op-ed, I guess, in the Wall Street Journal either yesterday or today by Vivek Ramaswamy and Elon Musk about what this Department of Government Efficiency, which actually isn't a department, it's actually maybe a committee or an office as a legal matter, but not a department because Congress didn't create it, what their authority is going to be. And the op-ed makes a lot of really broad claims that I'm skeptical of in terms of what can be done unilaterally without legislative approval. As a general matter, Congress is the prime mover. Congress is the initial entity. There certainly are lots of things that are worth, in my view, that are worth cutting or worth doing differently. There is an argument that something called the Impoundment Act is unconstitutional. So there's this argument that the president, at least in some contexts, has the ability to refuse to spend money that Congress has appropriated. I'm skeptical. So I think a lot of the claims that are being made with regard to Doge are an example of a broader phenomenon that we have observed certainly in our presidential campaigns for a few decades now, where presidents talk as if, and presidential candidates talk as if, that when you come in as president, you get to make all these really broad decisions unilaterally. And that's just not the way the system works. Are there going to be contexts? Now, there is an argument that as a result of decisions like this, it should be easier to identify things that agencies are doing that they never had the authority to do. And then all you would be doing by telling agencies to stop doing those things is following existing statutes and not going beyond them. And then if those things were challenged, presumably that would be upheld. But I'm at this point a little skeptical of the claims of the ability of the president to appoint some folks to what's effectively a committee that can unilaterally take apart large swaths of the bureaucracy. And now Congress could authorize something like that, but I'm skeptical of their ability to do it unilaterally.
I'd like to invite you to join me with thanking Jonathan for the excellent talk and answering questions, taking time with us. Thank you very much, John.